the State of Illinois versus Robert Crimo Jr., 22 CF 2074. The defendant is present out of custody, represented by his attorneys George Gomez and Ilana Meyer. The state is present through State's Attorney Eric Reinhardt and Assistant State's Attorneys Todd McCutcheon and Jeff Fatlin.
All right, this matter comes on today for bench trial. Parties update me.
Yes, Your Honor. First of all, because your instruction was so clear regarding Sam Crimo, the record should show that Mr. Jed Stone is here on behalf of Sam Crimo.
Okay.
We have other updates for you, but I think Mr. Stone felt that he should be here.
Judge, I represent Sam Crimo. I don't think I need to say more than that because what's going to happen, I believe, will moot any issue with Mr. Crimo.
Okay. Thank you, Mr. Stone.
Your Honor, the other update is that over the weekend, the parties have reached a negotiated plea in this matter for your consideration.
All right, and what is that?
The negotiated plea would be that in exchange for a plea of guilty to 7 counts of misdemeanor reckless conduct, obviously the state would be amending its felony class 4 reckless conduct counts to 7 counts of reckless conduct class A misdemeanor, which we would seek leave to submit to you. We have the written information. The defendant would be placed on a period of 2 years probation with standard conditions, 100 public service hours, open mandate for treatment, no FOI, no firearms, surrender sane, and he would serve 60 days in the Lake County Jail.
All right, have the victims' families been consulted about this?
Extensively.
All right, and have they been admonished regarding their rights to present victim impact statements?
I can check on whether we've been discussing that with them, Your Honor. We've gotten their input on the input on the plea negotiations extensively over as the day went through on Sunday. If I could have a moment on that. For what it's worth, Your Honor, the Class A endangerment statute that's being proposed to me, Your Honor, for disposition is the endangering wing of the Class A reckless conduct. So,
Okay.
if that impacts the triggering of the victim impact.
It does not.
So, Your Honor, we took a great deal of victim. We worked all day on it yesterday. I personally spoke to victims late into the night last night to get their input. Our understanding, and I might need a couple minutes to research it, Your Honor, but our understanding from our team is that the reckless conduct A does not formally trigger that victim impact statement requirement.
So is that a roundabout way of saying that they have not been admonished about victim impact statements?
Not specifically, no. They were consulted extensively, but regarding the victim impact statement, it doesn't sound like we had that specific conversation because of the definition of a violent crime and reckless conduct.
All right,
And I'm happy to research that more, John. I'm happy to look at that.
Well, that's while I point that out, the role of the prosecutor is really the one to ensure that if that's the case. So we'll move forward. Do we have the paperwork?
I am submitting them one by one right now.
Into the electronic system, you mean?
Yes, and then we have hard copies as well.
All right, please submit the hard copies. So that they give you amended information? Okay. Let's see what. And how are you submitting amended informations, new informations?
I did that through the prosecutor, judge, and I have a hard copy of the amended information as well.
Okay. Please bring that up. Mr. Crimo, is what I just heard from the attorneys your understanding of this agreement?
Yes.
Has anyone promised you anything I did not hear about?
No.
Is anyone forcing you or coercing you in any way to make you do this?
No.
You're entering pleas of guilty to 7 counts of a Class A misdemeanor, all of which are punishable by up to a year in the county jail, a $2,500 fine, or both. Do you understand that?
Yes.
Are you under the influence of any form of alcohol or drugs?
No.
Are you taking any prescription medications?
Blood pressure.
Okay, just blood pressure. Okay. You understand by entering this plea of guilty today, you're giving up your right to have a trial before this court or in front of a jury of 12 people, which you've already waived that. At that trial, you would be presumed to be innocent of the charges against you, which could only be overcome if the state could prove that you are guilty beyond a reasonable doubt. You would have a right to confront and to cross-examine the state's witnesses, to testify on your own behalf, and to call your own witnesses. You understand by pleading guilty today, you're giving up those rights.
Yes.
And the court costs are set forth in the court order, a separate order. The financial sentencing order, the court finds that those court costs are statutorily authorized, and you have to have those paid over the next year. Are you going to get that done?
Yes.
And the court finds that the defendant has an ability to pay them as well. Factual basis.
Thank you, Your Honor. The parties stipulate and agree that if called to testify, civilians and sworn law enforcement of the Illinois State Police would testify that on December 16th, 2019, Robert Crimo Jr., the defendant, signed and executed an affidavit in support of his son's application for a fire owner's identification card. At the time of this application, his son, Robert Crimo III, was only 19 years old and could not acquire a FOID card without parental sponsorship. Records from the Illinois State Police would show that the defendant's affidavit was submitted as an attachment to the FOID application of Robert Crimo III. Illinois State Police personnel would testify that Highland Park Police Department submitted a clear and present danger report for a review in September 2019, including allegations of conduct by Robert Crimo III that could not independently be confirmed or substantiated through their investigation, that there was no probable cause for an arrest of Crimo III, that there was no information indicating Crimo III had access to firearms, that Crimo III had no FOID card or pending application, that knives voluntarily given to Highland Park Police at the time were subsequently returned to the defendant when the defendant claimed that those knives were his property and not the property of Crimo III, and that consequently Illinois State Police law enforcement personnel had legally insufficient evidence to establish a firearms prohibitor. The Illinois State Police would further testify that absent any firearms ownership legal prohibitors, and in the absence of the defendant reporting conduct of Crimo III known to the defendant, constituting a clear and present danger, the Illinois State Police by law relied upon the written affirmations of the defendant that there was no reason Crimo III should not have access to firearms. Illinois State Police personnel would further testify that Robert Crimo III's FOID card would not have been approved without the defendant's sponsorship of the affidavit as required by law. Finally, Robert Crimo III's FOID card was approved and activated in late January 2020. Witnesses would testify that at the time the defendant sent the sponsorship affidavit to the Illinois State Police in December of 2019, the defendant was aware of the following: that his son had sent suicidal text messages as recently as September 2019, according to a forensic analysis of Robert Crimo III's phone, that the Highland Park Police Department had received information about threats to the family from Robert Crimo III in September of 2019, that the Highland Park Police Department had received information about Robert Crimo III expressing suicidal ideation in April of 2019, and finally that Robert Crimo III had expressed an interest in committing a mass shooting to Young Life Camp personnel in 2014 or 2015. Witnesses would further testify and establish that on February 6, 2020, Robert Crimo III purchased a Smith & Wesson M&P 15 rifle with serial number TM49842. That on February 7th, Robert Crimo III presented his FOID card to Bud's Gun Shop in Lexington, Kentucky to acquire that weapon via an online interface. Witnesses from Red Dot Firearms would testify that Robert Crimo III presented his FOID card on February 13th, 2020 to take physical possession of the Smith & Wesson M&P 15 rifle with the same serial number I listed above. The parties stipulate that the defendant because he knew more than the Illinois State Police as set forth above, was aware of the substantial risk to others when he signed the FOID sponsorship form in December of 2019, and that through these actions, he endangered the safety of Catherine Goldstein, Irina McCarthy, Kevin McCarthy, Stephen Strauss, Jacqueline Sue Sundine, Nicholas Toledo Zaragoza, and Eduardo Ubaldo, when Robert Crimo III obtained the M&P-15 on February 13th, 2020, and discharged the firearm that he purchased at each of those individuals on July 4th, 2022, at the Highland Park Independence Day Parade.
So stipulated?
So stipulated, Your Honor.
All right, and Mr. Crimo, once again, do you feel that you have had a sufficient opportunity to discuss this decision with your attorneys?
Yes.
Have they answered any and all questions that you've asked them?
Yes.
And based on all those conversations and your review of the evidence, do you believe that it is in fact in your best self-interest to enter this plea?
Yes.
All right, the court finds a sufficient factual basis and knowing and voluntary waiver of the right to trial, and the court will accept the negotiation pursuant to that in 22 CF 2074 for the offense of reckless conduct, multiple counts, which is a Class A misdemeanor. I'm going to place you, sir, on 24 months of probation with the standard indicia probation, 60 days in the custody of the Lake County Sheriff, 100 hours of public service, pay the court costs of this case, surrender your FOID card and any other firearm ammunition that you may have. You're not to sponsor any other minor children for FOID card applications in the future. The case will terminate on November 5th of 2025. And obviously the other charges are superseded by the additional counts of the information. So are we taking him into custody today? Is he beginning today to serve the sentence?
No, Judge, we're going to be requesting that he be taken into custody on a later date.
All right. So when would that later date be?
Judge, if it's possible to get November 15th.
Pardon me?
November 15th.
November 15th. All right, so the surrender will be in courtroom 812, November 15th at 9 o'clock by agreement of the parties. So, sir, if you wish to attempt to withdraw your plea in this case, you would need to file a written motion to do so within the next 30 days. Your motion would have to set forth all of the reasons why you wish to withdraw your plea. Any reason that you fail to put in your motion could be considered to have been given up by you or waived for the purposes of appeal. If I granted your motion, the case would once again be set for trial. Any charges the state dismissed could be reinstated and set for trial also. But if I denied your motion, you would have 30 days to file a written notice of appeal. And if you were unable to afford an attorney or a transcript for that appeal, both would be provided to you free of charge. Do you understand your rights, sir?
Yes.
All right, sir. Good luck. Anything else from either party?
No.
Your Honor, if I may, I know that we've spoken about the fine fees and costs. There is bond that is outstanding. I believe that that bond will apply to the fine fees and costs.
All right, bond to apply. Anything else?
Nothing else.
No.
Okay, thank you very much. We're in recess.
Judge,